Welcome everyone to our webinar on our new Code of Conduct template. At Holmes Murphy Fraternal Practice, our work with clients is guided by 3P2E. Philosophy drives policy, policy drives procedures, procedures drive education, and education drives enforcement. This framework was developed by Dr. Lori Hart and Justin Ignati when they worked together at Pi Kappa Phi Fraternity. To assist our clients, we developed a tool to help with the policy part, a risk management policy template. It's the result of a lot of work by insurance professionals, attorneys, and higher education resources. And if you haven't compared your policy to our template, we encourage you to do so and then reach out to us if you'd like assistance updating your policy. The Code of Conduct template that we're rolling out today is another step in the 3P2E journey. My name is Bobby Larson, and I serve Holmes Murphy as the education consultant. I'll be your moderator today. Before we begin, I want to go over a few logistics regarding the audio and web-based features of today's program. The only people you'll be able to hear during the webinar are our presenter and me. Any questions or comments should be proposed in the messaging panel on your screen. If your messaging window does not appear, click on the icon that looks like a conversation bubble at the lower corner of your screen. The presentation you're viewing right now will be advanced remotely, so just sit back, listen, and watch. If you have a question throughout the program, feel free to type it into the message panel on the screen. And just so we can practice that as well as see who is participating today, please type your name, organization, and the role you play into the messaging panel right now. We'd love to be able to welcome you. Please note this webinar is being recorded to allow those who are not able to join us today to gain access to the material. I am so happy that Justin Ignati has worked with us to develop this Code of Conduct template and is here today to roll it out. Justin is a graduate of American University, where he started his career serving students as an RA. He spent a number of years at Pi Kappa Phi Fraternity working in standards and accountability. He's getting ready to start his third year of law school at George Mason University, where rumor has it that he's at the top of his class. He served on the board of the Association of Fraternity Sorority Advisors. Lori Hart will tell you that he is the smartest person that she knows. But he has the ability in a practical sense to balance the legal piece of conduct with the student development piece, and we're fortunate to have him leading this webinar today. Turning it right over to you, Justin.
Awesome. Thanks, Bobby. And as a random note, my chat thing says chat not available. So I don't know what that means. But I passed it along. Well, excited to be with everyone. Far too kind of an introduction, and none of those things are true other than me being a law student and spending a lot of time at Pi Kappa Phi. So I'm going to walk through a little bit of conduct background, and then we're just going to spend the bulk of the call actually walking through the new template. So regardless of where you sit, thinking about whether you have a current student conduct code somewhere in your organization's bylaws or a separate document, or if you literally are starting from scratch, ideally the template that we're to develop will help you either review what you already have or give you a place to start. So as Bobby said, we have to start with a little 3P2E. And so when we think about conduct, we're really thinking about enforcement. That tends to be the E, but within that, you do a little 3P2E again. And so you will see in the document, it starts with philosophy. It outlines the policies, the rules that students have to abide by in chapters, then talks about the procedures by which we follow or that we move through in a conduct process, how you actually adjudicate and investigate a particular incident. And then the sanctions are really the educational piece. They're the how do we prevent this type of violation from occurring again in some reasonable period of time. And as a catch-all, you tend to come back to enforcement when somebody then doesn't follow the sanctions that you've outlined. So within the template, you should see the same 3P2E play out, even though we're in the final E of with enforcement. Some student conduct basics, if this is not your big background area, at its core, student conduct should be an educational endeavor. When I started at Pi Kappa, yep.
I'm sorry, can I interrupt you for 1 second? I'm not
Sure
seeing
can.
anything on my screen. Are you sharing your PowerPoint right now?
Oh, in theory, technology is helpful. How about now?
Not yet.
Loading content now?
Loading, it's loading. I see it spinning.
I love the spinning wheel.
Yes. Yes, there it is. Thank you.
There we go. You didn't miss anything other than a slide that says philosophy, policy, procedures, education, enforcement. At its core, thank you, Bobby. At its core, student conduct is an educational endeavor. When I started at Pi Kappa Phi, and some of you may find yourself in this position, our conduct code was about 3 pages, and it very much read like it had been written by a lawyer. And while it was fine, it was probably more procedurally heavy than it needed to be, and it ultimately wasn't flexible enough to actually think about how are we addressing things in a timely manner so that students really are engaged in an educational endeavor, in correcting behavior and learning what they should be doing, rather than getting bogged down in what form they have to fill out and how a particular process works. Conduct is a shared responsibility with students, and so that should be reflected in how you approach the work. And we expect students to abide by certain standards. We also expect them to accept responsibility in the conduct process when they have not lived up to the organization's expectations. Its ultimate goal is to protect students' rights, health, and safety. And I think there the key balance is that it is both about health and safety as well as the rights of students. In a private organization, students only have the conduct rights that you afford them. And so we will talk a lot. The basis of the code is the idea of fundamental fairness. That is not a standard you have to use. But I think when students trust that the process is fair and is going to reach a reasoned outcome and that they've had the opportunity to share their perspective, I think you end up with a more educationally focused process, and they walk away ideally thinking about, okay, what are these things we need to do to not violate the policy moving forward, rather than feeling like they got hosed in a conduct process. And several of you may have had that experience in working with institutions or even your own process at your organization, just feeling like the students always walk away with a bad taste in their mouth. And so thinking about what rights should they have in this process, and how do we make sure those are protected, even when it's perhaps inconvenient for us. And the process should be impartial and fair. Having been a person at the headquarters who did student conduct, you are the investigator, often the adjudicator, the sanctioner. And so just making sure that as you're going through that process, although you're wearing many hats, that you really are thinking about, am I making a balanced, fair decision here about what evidence and information I have in front of me? Or am I doing this sort of as the role of the prosecutor? My job is just to build the case and sort of then sanction on the back end. And ideally, you really are looking for what happened and then making a reasoned decision about what the outcome should be. The keys to success as you think about the code, hopefully the template reflects these. Did my best. It should be written in plain English. And so what I will say is if you've got a lawyer on your board or who on staff or somebody who's going to review this, an alumnus and alumna, probably go back over it yourself and say, well, you'll find in the template, we don't use the word shall, I use the word must, because shall tends to sound a little overly legal. You will not find any whereas or herein. So just thinking about, would the average person be able to pick this up and understand it? Because at the end of the day, it's students. They're the ones who need to be able to read this. As a general rule, it should follow in chronological order. Makes it just easier for you to know where you are in the process. It should be aligned with whatever philosophy statement you open with. And so if the philosophy statement says that this is an educational endeavor, then does the process really lend itself to that? It should allow you to handle matters promptly. But it should be uniformly applicable. So the process should work whether it's an individual student, a chapter. It should work whether or not the chapter incident is hazing or a low-level alcohol violation. And so if you find yourself in a place where the process always feels like it needs to be tweaked a little, that's probably a good place to start into the template and say, okay, well, let's come up with a better process that we can more uniformly do. Also makes your life a little bit easier to just know this case gets handled this way. And again, avoiding legal jargon. So just writing in plain English and in very short, crisp sentences where it's clear who's doing what or is not allowed to do something is very helpful. In the conduct process, language does matter. And so throughout the template, you will see that we use conduct rather than discipline. We'll talk about fundamental fairness rather than due process, which is a legal standard. People are complainants and respondents. We use the terms meeting or hearing versus trial. There are hearing panels instead of tribunals. The standard that's proposed in the template is a preponderance of the evidence. It's more likely than not that a violation occurred or a fact is true. You're certainly welcome to change that, but it's your basic 50 and a little. Responsible and not responsible. You also see sanctions are assigned rather than imposed. And we use sanctions or outcomes. The template uses sanctions, but you can always change it out instead of using things like penalties. And so that I think is probably, particularly if you're working with folks who don't have a conduct background, their language tends to be the place where you just have to get them on the same page about how we talk about these things. And over time, you find that people just sort of catch on. So the template itself, before I actually pull it up, a few notes. Its focus is students and student chapters. So if you adjudicate or would like to adjudicate alumni misconduct or alumni misconduct, whether alumni chapters or just individual alumni, that is not how the template is written. And so you will need to go through and either decide, yes, I want to use this exact same process for alumni and alumni chapters, or no. I think you could make a very reasoned argument that alumni misconduct or alumni chapter misconduct is not an educational endeavor. You have enough on your plate with students that maybe you like something that's a little more summary action, like we just send you a letter and that's the outcome. We're not going to do this in the same way. We're not going to engage with a 50-year-old in the same way we do with an 18-year-old. And I think you could be very reasoned about that. If you think, nope, this process works for us, then just make sure that you find all the places it says students and student chapters and you update it so that it actually reflects what you're going to do. It is intended just to be a helpful starting point. There is a lot of information in here. And so as you read it, when you think, I don't like that, you just delete. So you can take things out that don't work. There's a lot of places where you'll see highlighted language that needs to be organization specific. There is no one size fits all approach to conduct. And so the goal is to sort of give you the widest possible array of options so that you can pick off the menu what you really want in there. The basis for this was the NACURM group has a model student code. They have a public institution version and a private institution version. And so I used, and they are given credit at the end, adapted pieces of their private institution code. I went back to my Pi Kappa Phi days, having been the staff member responsible for redrafting ours, which was a combination of a number of private universities' codes of conduct. And so there is some background and where some language comes that you may have seen before. And so you're just going to work through the template and really figure out what works for us. The layout, as you will see, there are drafting notes in each section, which should be flagging things for you, like the template suggests it this way, but there is another way for you to do it. And so what you have in the template and the actual language is what I feel from a student conduct perspective is best. The template was reviewed by Jennifer Rizzo, and so it's also had a set of legal eyes. And you'll find sometimes, I think, in the drafting notes that there will always be a little bit of tension between how much an international organization does on a student conduct front with individual students, or how frequently they're doing individual student conduct, or how much they are able to direct people at the chapter level to do things, versus what I think is a practical perspective about how you do conduct and the ability and flexibility you need sitting at the international organization. And so that tension, I think, becomes apparent, and you just have to make some reasoned decisions about how much authority does the national or international organization have, how frequently does it exercise that authority practically in the conduct world versus what that may mean if there's litigation later. And so the drafting notes hopefully help give you that perspective. There's some bracketed text throughout it in blue, which is intended for you to replace that information with whatever is specific to your organization. It's places where you'll see language like standards board, executive director, that really should be organization specific. And then there's bracketed text in yellow that is really intended to be alternate language. So you might dates, amount of time tends to be in yellow. Like, do I think 10 days is good, or do I want to pick something else? Versus terms that tend to be organization specific, which are what you'll find, I think, usually in blue. And as I said, the language matters. In the document, must language is mandatory. It would be the equivalent of using a shall, and ideally, as it was drafted, actors go with the word must, so people in processes. May is permissive. So if it says may, it's an option. You don't have to do it. The executive director may interimly suspend. An interim suspension must be delivered. Notice must be given in writing. Those are different, right? So notice has to be in writing. Interim suspensions are optional. You'll also find in the document, or is meant to be disjunctive. So first thing I learned in law school was and/or is not real. If it's or, it means anything in that list could be true. If it's and, it means all the things in the list must be true. So in a list of things you could charge a student or chapter with, it's a long list and ends in or, because you actually don't charge them with all of them at one time, you pick one. But if it says and, it means you have to do both or all three, depending on the list. So if you're wondering as you go through, you should be able to tell. Or means any of them will work, and means they all have to be true. So I will flip over to the template. And as I said, it starts with philosophy, and it is the first place where there is just blue text that says you need to come up with a philosophy statement. There are some notes here about things it should include, right? It should emphasize personal responsibility. It should be education-centered and prevention-focused. It should say that students and chapters are expected to accept responsibility for their behavior, but you really should spend some time thinking through what is our philosophy, and like in everything else that you do in Holmes Murphy land, philosophy really should be driving the choices that you make. It also is helpful then when students are introduced to the philosophy. If you do conduct board training with your chapters, when you introduce students to a philosophy, it also gives them a backstop. So they may not remember exactly how many days in advance a particular email has to go out charging someone, or what documents they're supposed to be sending to who. But if they can remember, our goal here is education focused. Our goal is to prevent future violations or to change behavior or reduce future violations, then they can make better decisions. The goal is for them to come up with impactful sanctions and people to feel like it was fair, not to check the box and say, well, we sent the letter 3 days in advance, so the conduct process worked. If that's where they're spending their time and energy, they're probably not doing it right. And so spending some time on a philosophy statement, Lori can certainly share. Packet of Fives, it very much follows the others that we have, but something that documents what the philosophy of the organization is. The next section you'll have is jurisdiction. And so this is one of the places where you will see a little bit of the tension between what may work and what may be better for you on the back end legally. So there is language in section 2.4a, which talks about the international organization's jurisdiction. It says the international organization may adjudicate any alleged misconduct by a student and any alleged misconduct by a student chapter. The note that you have is that may mean, obviously it means that you can do that. It doesn't mean you have to do that, but that you may decide that the international organization is only going to adjudicate some more egregious level of alleged misconduct by chapters or by students, so that you're not put in the position where it seems like the international organization is taking up every student conduct case. The key to remember if you're going to tweak the language is just make sure that when you read it, you know what it means. So if you're thinking about, well, I'd like it to be more egregious violations, then I would just be prepared to know when I say egregious, what does egregious mean? And if you're asked in a deposition later, well, what is an egregious violation? Is it underage consumption of alcohol that violates the law? Is it provision of alcohol to a minor that violates the law? I mean, where are you drawing your line, and what is really egregious behavior that falls into your ability to adjudicate? As you'll also see throughout here, students is the language that's used. So you may substitute language. It is meant to be uninitiated new members and initiated members. So it just the easy default is to use student in the template. So you'll want to figure out what we want to call people. And then student chapters is undergraduate chapters. So that's the first section, just who has the ability to do what? What do chapters adjudicate, and what does the international organization adjudicate? Then you get the laundry list of prohibited conduct. The student misconduct section, which is 3.1, mirrors in large part to the student chapter misconduct section, but it literally just says students may not, and there's a long list of things here. It's A through O. I don't even know how many letters that is without counting them. So this is where I think a place where you will really want to go through and say, do we want all of these in here? And what is missing? So it's everything from violating the trust imposed in you as an elected or appointed leader to endangering the health and safety of others, causing a reasonable expectation of harm in another person, creating a health or safety hazard. I mean, you'll see these are some places where creating a health or safety hazard is not clearly defined. So there are examples like hanging out of a window, climbing on a roof, those kinds of things. Violating applicable state, federal policies, federal or state laws and applicable policies. And then there's just the laundry list of alcohol policies, drug policies, hazing, sexual misconduct policies, which then means that every time you want to tweak the policy, if you are in an organization where this is going to live in bylaws, sometimes just saying we're going to refer to a policy that then is much easier to amend is somewhat easier than detailing everything in the code that you have to wait until convention to modify. So just being conscientious of that. Failing to comply with the directives of an international organization, staff member, officer, or director when they're acting in their role. This may be a place where you add volunteers into here. Could be chapter advisors or regional volunteers. Failing to meet your financial responsibilities, damaging property, possessing stolen property. Some of these are definitely things that you would not normally find in an organization's conduct code. And so you may use them or you may ditch them and say, we don't need to be that specific here. The one place that the one that is not in here that is often in a conduct code, and it certainly was a pike of a phi, is conduct that reflects negatively upon the organization, another member, sort of the conduct unbecoming. So if you like to use that and it's something the organization finds helpful, making sure that you put it back in here because it is not in the current template. And then they mirror. So student chapter misconduct follows the ones that would make sense for a student to violate or a student chapter to violate versus a student. So this is probably a place where you need to spend some time saying, does this cover everything? Or if you're reviewing your own organization's conduct code that already exists, are we missing some of these and it would be helpful to have them, or it would be helpful to word them this way? So a good place to look. The next section is on interim suspensions and who can issue them, who has the authority to issue them. And so there is language here again where you'll want to consider, does your executive director, chief executive officer, chief staff member, chief volunteer, whoever it is, what authority or how frequently are they willing to issue interim suspensions? So there is a note here that you may again want to consider only doing it in egregious misconduct or some other limited set of circumstances, but it is broadly written here in the actual template. You'll substitute executive director for whatever it's meant to be your chief staff officer. If you don't have a chief staff officer, who would be the person that if a student or chapter had engaged in some level of misconduct where you thought in the best interest of the organization or the health and safety of others, we need to put them on pause? Who would be the person that would do that? And that's the name that should be replaced there. The template also, there's a footnote that tells you the template uses their in its singular and plural form. For some people that is confusing, but I didn't really want to do the he/she everywhere through, and it's also gendered. So if you know that the executive director is a man and it's a he, then you can just substitute he for there, but there is used both singularly and plural. So just be conscientious. Interim suspension language that's in here suggests to you that interim suspensions not exceed 60 days unless justified by an extenuating circumstance. There is language above in the drafting note that you may consider just saying that it can continue and that it's more open-ended until the incident has been resolved or any pending university criminal or civil matter has been resolved. I personal opinion is that would be an extenuating circumstance. And so I think if we're really thinking about this from a fairness perspective, the student knowing this goes for this long, 60 days is normally more than enough time to investigate and adjudicate a particular incident. But that if we're not done, we'll just extend it. And so it gives you, I think, the flexibility, but also normally communicates that we should be doing this quickly. An interim suspension should not be something that goes on for 4 months because we were busy. Then at that point, it's not fair to the students that are involved, unless the circumstances really justify it. It also gives the student who's been interimly suspended the ability to meet with whoever the suspending authority was. So in this case, in the template, it's the executive director or their representative to talk about why the interim suspension is not merited. So they would request it, you would hold a meeting. The template suggests you get 2 weeks to hold the meeting. And if you don't hold the meeting in the required time frame, the suspension lifts. So if you are like, I don't like that sort of if then make sure you adjust the template as you go. And really that the focus of that meeting is about the reliability of the information and whether it's actually reasonable that the student or chapter be suspended in the organization's best interest. And so it does give the student the ability there that they can sort of appeal that outcome back to the person who issued it. But so you just have to sort of make a decision about whether or not that's how your organization chooses to operate. It also gives the chapter's executive board, which is the default term in here, the ability to interimly suspend individual chapter members. It has a vote requirement, so this uses 3/4. My perspective in drafting it is that it shouldn't be impossible to interimly suspend a member of your chapter, but it shouldn't just be done sort of on majority whim. And that probably is just my perspective working with some of the men that I used to work with. But and then at the chapter level, the timeline that they have for an interim suspension is much shorter. It's 30 days. Shouldn't take a chapter more than 30 days to adjudicate unless justified by extending circumstances. So that might be pending university, civil or criminal case, the end of an academic term. All of those things would work as, yes, your interim suspension is going to carry on past 30 days, and we're just going to tell you that. And then it mirrors the same process. If the executive board votes to interimly suspend, the individual student can request to meet with them and explain why they don't think that's appropriate. What it does not have in the chapter interim suspension section, if they issue it, is any requirement that they copy information to the national organization. And so if that is important, I know in our code, it was required if a member was interimly suspended within a certain number of days to send notice to somebody at the headquarters. If that's something you do, it's not currently in the template. So just making sure yeah, we want to know that so that we make sure chapters aren't abusing this authority, or we would prefer they don't appeal to the chapter executive board. They can appeal to a regional volunteer. These are all places where just because it's in here doesn't mean it's the only way or the best way. It's just a starting point for you to think through what would we do and how would we do it. There are some definitions and roles in the conduct process. So a complainant is the person bringing the complaint. A respondent is the student or chapter accused. A witness is someone who has information, and then it uses the term investigator. That is an organization staff member or volunteer who looks into the alleged violation and then shares that evidence on behalf during a hearing or a meeting. So the complainant here also tells you who can serve as a complainant, and so just have to make a decision about whether or not you allow non-members to be complainants, or if they have to give their information to a staff member or student or a volunteer who then really serves as the complainant, and they just become a witness. The key normally, as you go through the conduct process, as you think through that, is complainants normally can be in the hearing or in the meeting the entire time. They're sort of the other side. Witnesses only come in for the amount of time where they're presenting information. And so just making a decision about whether non-members can serve as complainants and would sit through the entire hearing, or if non-members can only serve as witnesses and just come into a hearing or an adjudication for their particular testimony. Procedural standard talks about preponderance of the evidence. It also includes the factors for finding collective responsibility. So this is a mix of the NCRM code and then some other language from other codes, but these are the factors that individually or in combination, depending on which one it is, would indicate that the chapter has collectively engaged in a violation. These are often not in codes, whether at a university or not, they should be. I think it's helpful because you then know, as the adjudicating body, whoever it is, the hearing panel is making a decision, what evidence they're looking for that this wasn't 5 people, this was the whole chapter, or it really was just 5 people because these other factors aren't there. So this sort of mirrors a little bit of what you see in the event planning guide, sort of the questions that you would ask yourself to think, okay, is this going to be seen as a chapter event? Here they're just written as factors you would consider in an adjudication to know if this is collective chapter behavior or individual chapter behavior. And then just some general disclaimers, like we're not using the formal rules of evidence, and that just deviating from a prescribed procedure doesn't mean that the decision isn't valid. So the way it's drafted here is significant prejudice. So if you sent them an email 10 minutes before the hearing and we're like, get in the hearing, then they could argue, well, I was extremely prejudiced by that. I didn't have time to prepare. But if you were supposed to send an email 2 weeks in advance and you send it 10 days in advance, it's probably not a big deal. So there is a note here, though, that if you don't allow students to appeal procedural error, just delete this section because there's no point in saying it if you wouldn't allow them to appeal an outcome on it. Section 7 is all about rights. So it's a good place to make sure that you've been clear about what rights a student or a chapter in the process the respondent has. And they're pretty broadly written, and I don't think they're unfair. To be informed about charges, to ask that it be resolved informally, to have time to prepare a defense, to hear the evidence that is the basis for the charges, to appeal, and to waive any of those rights. If you don't allow chapters and students to appeal decisions, which you certainly don't have to do, then just make sure that where the appeal stuff comes up that you remove it. And then there is a caveat that what the role of the advisor is, that they're just there for support, and the way the code suggests it, only members or staff members can be, so students, volunteers, which could be a member or non-member, but somebody connected to the organization can serve as an advisor. So if you allow non-member advisors, then making sure that that language reflects that. So if a parent could be an advisor, even though they're not a member or a volunteer, just making sure that you've updated the code. The resolution by the student chapter will somewhat mirror what you see with the resolution by the international organization. It uses the term standards board, but it's highlighted everywhere, hopefully, so you can catch it as you do your control F. I think I also tried to highlight if there are cross references to other sections, so that if you start deleting and moving things around, or you prefer not to number them the way they're numbered, that you catch where the places that there's a cross reference. So rather than saying, if the person alleging a violation of the code does not meet the qualifications outlined herein to serve as a respondent, which then you're like, what does that mean? It just tells you, or a complainant, just tells you go back up to 5.1, where it defines that a complainant has to be a student, a volunteer, an alumnus, or alumna, or a headquarters staff member. So if you tweak one, just making sure you update the section. But essentially, it says that you report to the president and to the standards board chair in writing. They then sort of move through. It talks about them not having conflicts of interest. So if it is the standards board chair who is accused of alleged to have done something, that they cannot serve in that role, and it makes that clear. Shouldn't have to say it, but sometimes you do. And then it just walks you through, right? Once they get a complaint, they set a date and location for the meeting. This says they have 15 days to hold a meeting unless extenuating circumstances justify it. Feel free to adjust time. They get their written notice 5 days in advance, and then there's the musts, right? You have to tell them what part of the code. So, under section 3.1, little a, you violated a position of trust imposed, from your elected or appointed leadership position. So what part of the code are they charged with? What's the nature of the allegation? In sufficient detail that they can prepare a defense. This is the thing everyone always wants in a charge letter is, great, you charged me with this part of the code. What did I do? On or about this date, it is alleged. That's what they're looking for. And then when is the meeting going to happen and how? Particularly now, letting people know this will occur via Zoom or whatever it is, totally fine. They can resolve it informally if they agree to findings of responsibility and sanctions, or they have a standards board meeting. They listen to evidence, and then at the end, they ultimately weigh that evidence to make a decision. It does indicate that it allows for character witnesses, but they can be limited if it just feels unnecessary, which it usually does, and that the standards board makes a decision, keeps minutes, and then ultimately sends out an outcome letter within 7 days of the meeting. So tweak as you go there, and it tells for the students exactly what needs to be in the notification, right? And also suggests that if they're going to suspend or expel a member, that they have to report that to the international headquarters, and what documents they would need to include. So if you like all conduct outcomes reported, you'll need to tweak there. My PICAP experience was that we only wanted suspensions and expulsions because nobody had time to wade into anything else. And they didn't change a member's status, so it didn't matter. Same follows resolution by the international organization. The template uses a committee of trained volunteers. That is, and it's written as a committee. You can call it whatever you want, but the idea would be every year, whoever does the appointing in your organization gets a pool of people, 10 or 12, does some training with them so they actually know how the procedure works. You talk a little bit about student conduct if that's not their background, and that they actually know sort of what's going on. And then the way the particular resolution is set up, you use 3 out of that pool for each hearing if you're having hearings. So it talks about investigators. So the executive director's authority to appoint an investigator, whether it's a volunteer or a headquarters staff member, that their job is to prepare a report summarizing what they find, to gather information, to be prompt, thorough, and impartial, and to really then summarize in that written report whether there's sufficient evidence to proceed in the conduct process. So not a finding of responsibility, just that based on the information, there's sufficient evidence to allege the following code provisions were violated. Should not be written as a finding that the following code provisions were violated. That should be left to the adjudicator, whoever that is. Section 9.3 is the informal resolution procedures. So this is really, if you're a staff member or a volunteer who does this day to day, this is you. This is you find out what happened, you propose a set of outcomes to the chapter. They say, yes, this all sounds lovely to us, and we just agree. There's no big formal hearing. This is written that the chapter agrees. They accept responsibility for the violations that you outline, and they agree to complete the sanctions. If you are at an organization where you just have the ability to issue sanctions to chapters, then you'll want to tweak this particular section. But my experience, my time at Pi Kappa Phi was that students always accepted sanctions as they were proposed. They sometimes had different thoughts, and we went back and forth on what was going to be most helpful. But that largely, if we were proposing outcomes to them, they thought they were fair enough to take. So it does sort of give you that process of how you would go about doing that. But if you do not, if you're at an organization where you just issue sanction letters, then you'll want to tweak that particular section. And then the hearing procedure works the same, right? So the International Governing Board or executive director or their designee, which is probably going to be a staff member, appoints a committee of panelists, get your pool of people, you do a little training, you pick a chair, and then in those procedures, the headquarters staff member or volunteer serves as the complainant, and we make sure that people very much follows the chapter process. They get written notice of when the hearing is and what they're alleged to have done. They get copies of pertinent evidence in advance. So this is where you really do want to weigh in and kind of figure out what you want to do. But this would say 3 days out, they get a list of all the witnesses that are going to be called, if there are any, copies of all of the evidence that's going to be presented, and the names of any advisors accompanying someone to the hearing. So the student would have to let you know in advance, hey, I'm bringing an advisor with me. And then the panel conducts the same thing, right? The panel asks questions. If the parties, the complainant or the respondent, have questions, the model that's proposed here is that you submit the question to the chair, and the chair at their discretion asks the question. So there's no opportunity under the proposed code for sort of direct cross-examination of a witness. So if that is something that your organization thinks is important for the person accused of doing something to be able to directly ask questions, then you'll need to make updates and also think about how that works depending on the particular case. So would you want a chapter president who is alleged to have engaged in hazing directly questioning a new member who reported that information to you, or would you want a different model to be used? So just walk you through. After all that, you excuse everyone, you come up with your findings, you keep your minutes. The code does not offer verbatim records, so we don't record calls or sort of take stenographer like notes, but whatever your process is, and then you send your outcome letter. So it very much follows the chapter model. Section 10 is special procedures for what we've kind of gone back and forth on what to call it, but sensitive complaints. It's the language NCCRM uses, so borrowing from them. These are things like alleged sexual misconduct, discrimination, retaliation after someone reports hazing. These are things where the identity of the person making the report or just the nature of the alleged misconduct is more sensitive, and so there are different procedures proposed. So what this essentially says is they're always investigated under, so this proposes that they can be investigated under section 9.3, which is the international organization's investigative power, and are only adjudicated by a hearing panel under section 9.4. So for the particular types of things that are alleged here, so this says sensitive complaints, including sexual misconduct and discrimination, are the two that they would only be heard by hearing panels conducted by the international organization. If that is something that you were like, yep, that makes sense to us, we don't want chapters doing this, they don't do well with adjudicating holes in walls, so this seems a little out of their league, great. If you don't like it, take it out. But wanted you to have sort of a basis. And essentially what it then says is if you're going to adjudicate any cases involving sexual misconduct, whether they're adjudicated by the chapter, if that's your model, or by the international organization, there are two things that are specifically limited here, that the alleged victim's sexual history is not admissible evidence in a hearing. So we don't talk about people's past sexual acts or the number of people they've had sex with or anything like that. And that only becomes, and then for the respondent, your member who is alleged to have engaged in this behavior, their sexual history is only admissible if it reasonably demonstrates a pattern or repeated or predatory behavior. And so it is actually written in a relatively fair way, I think, to say we're not going to get into your past sex life. We're talking about a particular incident, and we're not going to use that other information, unless in the case of the respondent, it's to show a pattern or some repeated predatory behavior. We're not going to use that to influence whether or not we find you responsible. So even if you decide that chapters and the international organization can both adjudicate sensitive complaints, including sexual misconduct, you could still leave section 10.2 because regardless of who adjudicates it, you may want to limit the types of evidence that are admissible. And largely, section 10.2.1 would follow how we would do that in an actual legal context, that an alleged victim's sexual history generally is not admissible to determine if a violation occurred. So section 10 is a place where probably some folks internally within the organization are going to have to grapple with exactly how you want things to work. Section 11 is just sanctions. And so it divides them again, student sanctions and international chapter sanctions. There's a laundry list here. So you choose the ones you like, but they take you everywhere from warning to restitution to fines, community service, loss of privileges, educational programming. There's a note here, bid revocation. Is that a sanction that can be assigned by a student chapter by majority vote or by hearing panel? And then there is a note there that if you're going to allow for bid revocation to be a sanction, for you to define what then the student loses. Same with suspension. So he calls it a student's temporary separation from the organization for a designated period of time. You'll want to define, for us, that means you're not in good standing, or you may not run for or hold elected positions or whatever. It's broadly written. The same with expulsion. And so those would be individual student sanctions, and then there are chapter sanctions, and they mirror the same, where you'll want to go ahead and update language like, do you call it a charter revocation? Do you have another term for it? But they likely follow. They mirror each other. And then section 12 is appeals. If you allow for appeals, my recommendation would be to limit them and give the grounds on which you can appeal. So the three that are in here that are offered for you are procedural error that substantially affects the outcome, new information not available at the time of the adjudication that could substantially affect the finding of responsibility. So you have an entire hearing, and then the student who actually did it comes forward and is like, it was me. Right, we would appeal that and say, well, here's actually the person who did it, or disproportionately severe sanction in light of the violation. So just being clear about, it's not just an appeal, I don't like the outcome. What is it the student or the chapter has to be able to show in their appeal letter, and limiting them to some narrow set of grounds. It makes clear that appellate review, a place where you'll have to think through this. My experience is that appellate review is written record only. So it is the notice that went to the complainant, whatever evidence was presented at the hearing with the minutes from that hearing and the outcome letter. It is not a rehearing of the case. And so if you do have appeal hearings, if that's part of your procedure, then that section will need modified. Sanctions remain effective during the appeal. I would keep that in if you allow appeals. And then it just sort of delineates who can appeal. If the chapter standards board adjudicates it, who can they appeal to? Here, it says you exhaust your appeal at the chapter level, whatever the bylaws say, and then you can appeal up. But you may say, nope, we don't want to deal with every little chapter standards board appeal. And then what do appeals to the governing board look like? So the reason the code is written to have a pool of volunteers that you pick a panel from is so that your governing board can then serve as the appellate body, that they're not in the mix on adjudicating the case and then the appeal going to them. The other thing this does not have is an appeal to the convention. So that was my Pi Gamma Phi experience, was if you wanted to, you could appeal to the convention 2 years later. I think that's a little ridiculous, personally. And so the way the code proposes it is that whatever the governing board decides on an appeal, that decision is final. You could also certainly just set up a separate committee of people that just hear appeals, and that would be fine as well. So that's what's in here. The goal is really to provide you with as many good ideas as we could, and pull together a number of resources so that it was all sort of in one place. And then from there, you could sort of figure out, how do I tinker? And what do I really want this to say? So that's what I have. If there are any questions.
Yes. If you have
Great.
questions, please feel free to type them into the messaging panel. Thanks, Justin. You have such an ability to take this document and show us how we'd use it in day-to-day life, and I really appreciate your skill in doing that. We do have one question already. It's from Treyette Deek.
Sure.
Was there a note about how and why an interim suspension is issued? I think the field and many campuses jump directly to a full interim suspension instead of using interim actions such as just suspending new member activities or requiring new member activities to occur in a campus classroom with an advisor. Interim action should be only used to prohibit the problematic behavior and not normal operational behavior. Obviously, an interim suspension is valuable, but I'm just not sure that it's the first place to go. Thoughts as working that into the template?
Yeah, so the language currently is open-ended. It just says it is a broad grant of authority, right? The executive director or their designee may internally suspend. I think certainly I would say I agree with everything, Trey, that you said and what the purpose of an interim suspension is, how it should be used, when it should be used. So I think for you, you just decide sitting at DEEC, do I want it to just broadly say the executive director can do this, and then we internally as a procedure for how we implement this will limit it to, okay, it's only events without alcohol, it's only new member education, it's everything but meetings occurring on campus with an advisor or on Zoom with an advisor? Or do you want to then delineate that in the actual code? And I think that's just an internal decision for how you want the code to read. I would say that is absolutely the procedure I would go with. But I think that happens in a couple places in this document, is figuring out, do I want to limit myself in the grant of authority in the conduct code, or do I want to limit myself in how we implement it on the back end, right? So the other example that Jennifer and I went back on some comments on was, it says the international organization may adjudicate student misconduct and student chapter misconduct. There's language in there in the drafting note now that says, well, you should consider if it's egregious, where you want to sit that level. I take the approach of may adjudicate is we can, but we don't have to. So our procedure will limit when the international organization actually adjudicates individual student misconduct, right? We're going to say it's only going to be in the case of alleged sexual misconduct, hazing, theft, right? Like we internally are going to make that decision on what we say, no, chapter you handle, do not give that to us. So I do the same here. It's just, do you want a broad grant of authority that you limit on the back end, or you want to limit it in writing so that you're clear? But absolutely agree, only suspend the thing you need to suspend.
Thanks, Justin. And also, if you have not typed your name and your organization and your role into the chat box, please do that. It really does help us in this Skype environment keep track of who is participating so that we can make sure any follow-up information goes to you. But other questions, type it in the messaging panel. Tristan Conroy says, Justin, thanks so much for this. I have a quick question regarding joint investigations with the campus or similar. Is this in the document anywhere?
It is not, but I would, so that would be, so the document itself is not going to limit how you would do that. It gives the section 9. Right, it says an investigator gets appointed, they should be prompt, thorough, and impartial. They need to identify relevant facts and conduct interviews, obtain witness statements, and collect evidence, and they prepare a report. So it certainly does not limit you in any way. There's nothing in this document that says none of this information is ever shared, it's not released anywhere. And so I think it's written broadly that you have the ability to do a joint investigation without having to figure out, does my procedure allow that? If you want to make it clear, right, just go in and tweak. This includes investigations conducted jointly with host institutions. So I think as you think through edits you want to make, just figuring out, does this language allow me to do it? And we would just do it as a practice, or do I want to make it clearer that this is something that is specifically allowed because I think somebody would challenge it? I think the language is normally written pretty broadly. That's going to leave you with a lot of interpretation and flexibility, because at least in PICAP land, this was a document that lived in our bylaws. So if something was wrong on August 3rd in an even year, then we couldn't fix it for 2 years. And so it's meant to be written broadly that you can sort of have the flexibility you need in your day-to-day practice without having to wonder, is this falling within the 8 words that are on this page? But if you want to be explicit about it, I think it's a great idea to have in there that, this includes this. This doesn't prohibit us from doing these joint investigations.
Okay, thanks. A few more minutes, seconds to get your last questions in as we are wrapping this up. Thanks once again, Justin. You just do a really admirable job of combining the legal and the student development theory and making it real for us. We really appreciate your efforts in developing the template, but also sharing how to use the template with us. So thanks. The template will be available on our website as well as the recording of this webinar. The template will appear in moments. The recording may take a day or two, but we'll send out notice when that occurs. We would also invite you to check out all the other resources on our website. Here's my shameless plug. It's holmesmurphyfraternal.com. There's great coronavirus resources, great educational resources, and this code of conduct template will be shortly joining all those other resources. Please check them out. Lori Hart's contact information was on the last slide. If you have questions or follow-up that you would like to share with us, she is lhart, H-A-R-T, at holmesmurphy.com. I am B. Larson, B as in boy, L-A-R-S-E-N, at holmesmurphy.com. Feel free to reach out to us if you have questions or thoughts, and I would type that in, but I can't talk and type at the same time, so I will do that at the very end. We really appreciate your commitment to your organizations and your willingness to spend some time with us today. So thank you, and happy rest of your Wednesday.
Thanks, y'all.